give or take 3 months. And so what I'm going to do is I'll number the case. You have time this week to go out, go over all of the information with Mr. Anders. If something changed, I'll number the cases. I do have.
Ready for trial by week.
Okay, I have a couple that are older, but that doesn't mean things can't
Right, I
fall
understand.
apart.
So, I mean, of course, I'll still prepare and everything, but
Okay.
I'm looking forward to know.
I appreciate that, and just get out there, go over everything with Mr. Anders that you can. If something changes this week, based on you guys watching that you want to negotiate or something, then based on what you're telling me, I will allow there to be a plea after, which I normally don't do, but since you're just getting that, I think that's fair, Mr. Coleman. And so if something happens when you guys are watching that and there's some change and y'all negotiate, then we can get that taken care of next week. But I will do the numbering today, but I
Okay.
still want you to go ahead and go do all of
Oh, I
that.
will.
Okay,
All right, thank
perfect.
you.
Thanks. You can go back with the bailiff. What in- I thought my ears are red. Uh-huh. Oh, yeah, they are. I feel like all of it is. See, Elijah Miller, Mr. Lewis,
Judge,
do we need him?
if we can maybe hold on him for a little bit, I know we were trying to confirm his credit.
Okay, I'll hold on that just for, take them back, I'll hold it while y'all can get that figured out. And then, on David Greer, Mr. Kimler,
Yes, ma'am.
2 cases.
Actually, it's 3.
Yeah, they're separate. Same as the judge.
Well, because 2 of them had Mr. Parker on them, I guess. Initially.
And the other one was just indicted last week, so that's why it may not show.
Oh,
The
I
printed
did
document.
paperwork on it, so.
all right, sir, you're David Greer. Speak up for me, please. Thank you. And will your client waive the formal reading of the indictment in each case?
So is.
Judge on the state jail, the 26 cause number, which may we proceed just on count 1, but with the 2 bullet points that make the misdemeanor at state jail.
Yes, ma'am.
No objection.
Thank you. Bless you. Okay. So, Mr. Greer, in cause number 26, DCCR 0150, you're charged, the state has elected to proceed on count 1 only. It alleges that you committed the state jail felony offense of evading arrest or detention with previous conviction, and that's from October 2nd of 2025. It alleges that you were previously convicted of evading arrest or detention February 11th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And is that prior conviction for evading true? Get this one done, then I can get to the next one. Okay. And then let me find the other one. Sorry, give me just a second. They're not in order on here, and so I'm having to find them because I think they might be under. No. There they are. Sorry, y'all. Go paperless, they said. Okay, now in cause number 24, DCCR 2220, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon, and that's from August 24th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Speak up, please. And then finally, in cause number 25, DCCR 0324, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from January 27th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney's office, that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case.
Without objection.
It's admitted in each case. Is there any evidence that Mr. Greer is not competent?
None that I've observed, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent, and you understand the nature and the consequences of those pleas. Give me just a second to get caught up here. In cause number 26, DCCR 0150, sorry. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with a previous conviction. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 2220, also find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 25, DCCR 0324, find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will all run concurrently, which means together at the same time. I'm handing you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you should know this by now, but I'm required to read this to you. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. In your case, it could lead to another charge that could end up making you a habitual felon. You'll end up, next time, if you do anything else and end up in felony court, you're looking at 25 to life. Okay? So if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, good luck to you, sir. You can go back with the bailiff. Ms. Holmes, you have William Mallett's sentencing.
Morning.
Good morning. Thank you for your patience.
Judge, I have
the eye cutting and your reaction queued up whenever you laugh.
Good morning. Are you William Mallett?
Yes, ma'am.
And so Mr. Mallett was previously in court, entered a plea of guilty to obstruction or retaliation. Before we go forward, I got a pre-sentence report done and I've reviewed that. What's the status of, it shows there's a pending criminal mischief and evading arrest or detention,
So
or,
those should be under the misdemeanor.
okay,
Cases that he does still have pending, so those be taken care of in misdemeanor court.
okay, that's what I thought. I just wanted to
Yes, ma'am.
make sure we weren't looking at something else. Okay.
As far as
So-
I know, we don't have any other felony charges.
No reason not to go forward with sentencing.
Correct, Judge.
And so have both of you had an opportunity to review the pre-sentence report?
Yes,
We
Your
have,
Honor.
yes, Your Honor.
All right, any additions or corrections?
No, Your Honor.
Judge, just more of a suggestion. And I just want to make sure that his mental health issues are addressed in probation. I think
Yes.
that's going to happen. I just want to make sure I put that out there.
I will. Thank you so much for pointing it out again also. Mr. Mallett, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. I am going to recommend that Mr. Mallett be at least, it looks like it's already the recommendation that he's on the high need caseload with Spindletop. And so we're going to get you whatever help you need to be able to be successful. But it's important that you take advantage of that, okay? So if you have appointments, you have to go to them. If medicine is recommended, you need to take medicine. Whatever it is to make you able to be successful on this probation, we're going to give you those tools through probation, but you have to ask for those things, okay? Do you understand?
Yeah. Yes,
Okay,
ma'am.
all right. And so if you do everything that you're supposed to on this probation, then this is a great opportunity because you don't have a felony conviction. At the end of the probation period, if you're successful, the case will be dismissed. You'll never be a felony, have a conviction on your record. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court. You could be found guilty of the offense, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just go back with the bailiff, probation will talk to you today to give you your instructions so that you know what to do when you're released from jail, okay? And then I don't know if he has bonded out on those. Maybe you guys can request that he get those taken care of this on
Yes.
their jail runs this week.
Okay, I'll check to see if if they have him on the docket.
Okay,
If not, could you see what court he's in?
I can look it up for you.
Okay.
I don't know off the top of my head. I'll look it up.
Robert Lowe sentencing, Ms. Holmes? All right, sir, you are Robert Lowe,
Yes, ma'am.
and in cause numbers, okay, so we were here before, and Mr. Lowe had entered pleas of guilty in cause numbers 19, 32661, 32662, and 32663.
Yes.
There was an agreement that you guys had reached for a 7-year deferred probation. I rejected that plea agreement. We reset it. He went back through, entered pleas of guilty in those same cases open to the court, correct?
It was a cap of 6.
Cap of 6. Sorry. Cap of 6. And it's the same 3 cause numbers as well, correct?
Yes, Your Honor.
Okay. And then the agreement was for dismissals in the remaining cases as part of that agreement. Is
Yes.
that right also?
Yes.
And we reset it after that plea without getting a new pre-sentence report. We've already all gotten the pre-sentence report, reviewed that. Is that correct?
Yes, Your Honor. And we
Okay.
received a memo, well, it's the same pre-sentence report, we just have an updated memo from the mother of one of the
Victim.
people that he had photos, one of the children.
Yes, okay, and I reviewed that as well. Did you have an opportunity to review that?
I do not see, well, give me just 1 second.
Yes, ma'am.
Sorry. Okay, Judge, I've reviewed that in the original PSI. Obviously, the court is aware I was not involved with offers in this case.
Okay, thank you, ma'am. Any reason not to go forward now with sentencing?
No, Your Honor.
All right, Ms. Holmes, you may proceed.
Yes, Your Honor. We are still requesting that the court consider probation in this case. We do know, obviously, the offer of deferred probation was rejected, but we would like the court to consider possibly straight probation in this case. Mr. Lowe does not have any previous criminal history. One of the victims or complainants in regards to photos was his niece, in which I have been in touch with her mom, who is Mr. Lowe's sister, Brittany Lowe, in which I'm aware, the court is aware that they both submitted statements in which they are requesting that it appears that he'd received some type of probation, in which they're not requesting that he be sentenced to time. But they are obviously requesting if there's a no contact, which we believe is appropriate, and any other stipulations. So, Your Honor, we are asking that the court consider straight probation possibly, maybe the 6 years probated for 10 years, just to make sure that Mr. Lowe has a watchful eye on him to show that he can abide by the rules and regulations of the court. This offense did appear to be back in 2018. I will say to Mr. Lowe's credit, it doesn't appear that he'd have been in any trouble since that time. There were no new cases filed or anything like that. So I would say to his credit, within the last 7 years, that he has not committed any additional offenses. He does take full responsibility for his actions in these cases, and he's aware of what the possible maximum punishment will be. But I do believe that he can stay on the right track. The plan, if released and placed on probation, and that he will continue to live with his mother, who's 80, in her 80s.
I'm sorry, she's 73.
73, okay, she calls me quite a bit. But the plan will be for him to reside with her, which there are no children in that home. His sister and nieces, nephews live in separate locations. And so we're just asking that he be given that opportunity.
Ms. Malfino, I know you're just stepping in. Obviously, I have a lot of information that I've gone through with all of this. Do you have anything to add?
No, Judge, other than certainly I'm understanding of the court's hesitancy for the original probation offer, which makes it difficult for me to stand and argue for probation at this juncture. I appreciate the statements that they emailed in. However, due to the nature of the offense, my position would probably have to be pen time, Judge, or in lieu of that, maybe some type of a hybrid, whereas he goes to the pen in one and is on a lengthy probation on another. I know the court's
You read
not
my
your
mind.
favorite thing. So, based on everything you know, Judge, I'll defer to what you think is best.
Okay, thank you, Ms. Malfino. So I do want to make sure we're all on the same page. And I have done different types of hybrid sentencings before. But the first thing I want to make sure is everybody agrees with me legally that if I give probation on any of the cases, straight probation, that I can then give a 10-year sentence probated for 10 years, for example. Because it's probation, then that cap at the end, we've looked into that. So I want to make sure everybody understands and agrees with that.
Right.
So, Mr. Lowe, you know, I've already gone through at when we were here for sentencing before, obviously my issue with the plea agreement and the fact that it wasn't, not that possession of child pornography is in any way okay, it's not ever. But the fact that you actually took pictures of your own niece is the problem that I have. the initial version that you gave, it sounds like you finally came around and told at least somewhat of a truth, but the initial version of I was trying to protect children is just ludicrous, and makes no sense at all. So that gives me some great concerns. Obviously, if I just gave you prison time, I don't know that that gets me where I would like to be, because I think you need some treatment as well as probably some time, both, because I want everyone protected if you are out or when you are out, because you'll get out of prison. So what I'm going to do in your cases, in cause number 19-32661, find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of possession of child pornography. I'm going to sentence you in that case to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Then, in cause number 19-32662, also find sufficient evidence to find you guilty, and in that case, find you guilty of possession of child pornography. Sentence you in that case to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to probate that and place you on probation in that case for 10 years. In that case, I'm going to order a $1,000 fine and that you follow all of the rules and conditions of probation, which I'm going to talk about in just a few minutes. And then in cause number 19-32663, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. In that case, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 10 years. You'll be ordered to pay a $1,000 fine in that case and to follow all of the rules and conditions of probation. So here's what that means. First of all, you're going to do the 5 years first. Whenever you either finish that 5 years or make parole in that case, you're on probation in the other two cases for 10 years. And when you're on probation, what'd I do?
It's not 32663. That one, it's not that one. It's
60, 61, and 62.
yes. It's 32660.
Oh, the PSI is wrong. So the very last case that I just sentenced you on, which was 19-32663, I'm going to withdraw that. That was actually cause number 19-32660. And in 32660, I find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you to that 10-year term. It's going to be probated for 10 years, $1,000 fine. So with regard to those probations, once you're out of prison, you will be required to go through sex offender treatment. It will be a part of your probation. If you don't successfully complete that, participate in that, then it's going to be a violation and you're going to be right back in prison. And on those two cases, because I gave you probation, I was able to now give you a 10-year sentence instead of a 6-year sentence. So if you get out of prison and you get on these probations and you violate them, you already have a 10-year sentence. Do you understand? So whatever probation requires of you, but most specifically the sex offender treatment part of this, you will be required to do. And if you violate, there's not going to be any second chances for not showing up to your classes or anything like that. My goal is going to be protect everyone around you and hopefully make it to where you have the treatment needed to where we don't have this issue again. Part of your probation will also be in each case that you're not going to be allowed to be around any child under the age of 18 unsupervised. And so you can't live with anybody that has children. You can't be, again, unsupervised with any child under the age of 18. Do you understand? All right, I'm handing you in all three of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal in all three cases. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you.
Can I ask something?
Yes.
The no contact with no unsupervised, can we wait till after treatment's completed and just be no contact?
Yes, so there'll be no contact with any child until the treatment is completed. And then after that, it would be as long as it's supervised, okay? All right, go back with the bailiff. Mr. Lewis, did you work out something on Elijah Miller? Okay, and Mr. Gertz, I'll get to you as soon as we're done with that one.
The ledger's gonna ask for a reset if you want to just go ahead and reset. She's gonna be back down, she was at 279.
I'm in no hurry.
Okay, thanks.
Plus I was late, so. Yes, ma'am.
I know. Yeah, that's delays.
Oh, okay. I didn't know I saw her walk out. Jones and Compton. Is that still set?
All right, this is, are you Elijah Miller?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the
He
indictment?
does. And it's an MTRP.
Thank you. No, it says it. And will your client waive the formal reading of that motion?
Does.
Okay, Mr. Miller, in cause number 23, DCCR 0403, I have a motion to revoke your community supervision. Shows that you were placed on probation June 26th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed ever after receiving your probation. Is that true or not true?
True.
Count 2 alleges that you failed to report by mail since receiving your probation. Is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your correct address and contact information. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Miller's not competent?
No objection.
Let me look back at something real quick. Whatever happened with that probation that you were on in Orange for evading with a vehicle?
That was revoked and he was sentenced to 2 years TC.
Okay. All right, then I'm going to find, Mr. Miller, that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. And when I first sentenced you to this probation, you were given the admonishment regarding not possessing a firearm, correct?
Yes, ma'am.
Okay, so make sure you remember the conviction was back in 22-24. You were ineligible to possess a firearm in Texas because of that, okay? All right, good luck to you, sir. You can go back with the bailiff.
Thank you. You have a good day.
Thank you, sir. You too. Goodness. Okay. Mr. Gertz, you have, Vishal, or no given name Vishal?
First name.
This is Mr. Coleman.
Yes, Judge. You didn't have to participate if you don't want to.
Good morning, sir. Are you Vishal?
Yes, ma'am.
And this is cause number 25 DCCR 0507. Mr. Vishal was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was, I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge.
Not from the state, Judge.
All right, then, Mr. Gertz, you may proceed.
Judge, we're asking the court to consider probation. This case is